I lost part of my microphone, so I'm waiting on Amazon to send me a new one so I can wander. I don't like being rooted to the podium, but that's what we're going to do for now, I suppose. All right, so last week we talked about sources of law and just kind of basically how the American court systems are set up. For just to reinforce for my international students and my folks who weren't here last week, I'm not necessarily trying to get you to memorize or understand the inner workings of the American court system. I just want you to see sort of generally how it's set up and some of the features of it. And I want us to be able to kind of speak with the correct legal vocabulary. But this is not a law class. It's not law school. I'm not expecting anybody to know the law and finish this class and be ready to go take the bar exam. It's more about just sort of general literacy on the topics that we're going over. So today we're going to talk a little bit more about what happens in a court case and then what the process is that a court case goes through. And then at the end of the class, I'm going to talk some about alternative dispute resolution, which are ways to get a lawsuit resolved without actually going all the way to trial. So when I say litigation, that refers to court cases that are contested. In the civil arena, remember that's everything that's not criminal. In the civil arena, that's plaintiffs suing defendants for something. Because I would never do this, but my wife might. If she filed to divorce me, that would be litigation. Okay? If I sue Ms. LaFavor over a contract dispute, we're in litigation. Okay? And litigation is set up in our legal system to be an adversarial system, meaning we're against each other. It's just the way it's set up. I have a lawyer, if I choose to hire one, who is going to represent me, who's going to advocate for me and my rights and my side and my argument. The other side will get to do the same thing. In an adversarial system, we get to test or examine what the other side says. So I can't go to court in my suit against Ms. LaFavor and just say stuff. Okay? I got to be able to prove it. Her lawyer's going to get to ask me questions about what I say. I say that we had a contract. That doesn't mean that the judge in the case is going to accept as fact that Ms. LaFavor and I had a contract, because her position might be we never had a contract to begin with. So if I get on the witness stand or I present my evidence that supports the fact that I think there was a contract, her lawyer gets to stand up and challenge me on that. Okay? My lawyer gets to do the same to her. We're going to get to the litigation process here in a second, but I want y'all to be familiar with that term. Actually, let me skip to, because I already kind of started on that. Skip to page 2 of your outline. You only have a 4-page outline this week because it's very short. This would be probably the shortest one of the semester, so it shouldn't be hard for you to review that. But go to following a state court case. The way that a litigation starts off, the way that a court case starts off, is that the party who is bringing the lawsuit files a complaint against the person they're bringing the lawsuit, against the person against whom they're bringing the lawsuit. So remember we talked about the person who brings the lawsuit is named the what? Plaintiff. Person who gets sued is the what? Defendant. Good. In a criminal case, the plaintiff is always going to be who? The state, or if it's a federal criminal case, the U.S. government. Right? The defendant would be the person who's been accused of the crime. In a civil case, the plaintiff's just going to be the person who's doing the suing, and the defendant's the person who's getting sued. So a complaint is filed. That puts the defendant on notice that there's been a lawsuit filed against them and that they have to respond to that. When a lawsuit gets filed, it also gets served. You heard of service of process? It gets served on the defendant, usually by the sheriff or a sheriff's deputy or a private process server. But it actually has to be delivered and given to the defendant in order to get the case started. I can't sue Miss Marshall and then not tell her that I've done that. I can't sue Miss Marshall and just mail her, put a copy of it in the mail. We got to have some sort of verification that she got served with the complaint, so we know she got it. We know that she knows her time period is starting to run for her to answer, and so on and so forth. So once the complaint is filed, the lawsuit starts. Defendant gets served. Defendant then files an answer to the complaint. Complaints are usually, I've put an example up in your module. And on Thursday, we're going to kind of go through one. We're going to discuss one and go through it more in depth. But complaints are, the purpose of that is just to inform the court and the defendant who the parties are, what laws are involved, what the lawsuit is about, what the plaintiff thinks the facts are. All that gets laid out in the complaint. Defendant will answer that, and then we're off and running. Probably the most important phase of litigation is the discovery phase. And this is important, very important for business law. The discovery phase commences right after the lawsuit starts. Usually lasts 6 months. It can be expanded. Not asking y'all to know the exact dates of discovery period. But during the discovery period, each side gets to ask the other side for all the information that it wants or needs. It's information gathering. All right. If remember last week when I got fired by CSU, let's say that in that case I decided to sue CSU because I feel that they fired me for a discriminatory reason. During the discovery period, that's when I'm going to do all my investigating and digging into what evidence they have that will be useful for me. They get to do the same to me. Discovery takes different forms, so I do want you to be familiar with these different forms. Depositions. Anybody ever sat for a deposition? Good. I was hoping there would be nobody. Depositions are sworn interviews by a lawyer in the case. So it is a chance for the lawyer to ask either the other party or witnesses. You don't have to be a party to the lawsuit to get deposed. We'll talk about that in a second. I'll give you an example in a second. There's a court reporter present taking down every word of every question, every word of every answer. That gets printed up in a book form, and that way we've got written, sworn testimony to use in the case. There's an example of a couple deposition pages in your content module. So, what are some of the advantages of taking a deposition early in the case? Well, we want to find out what the other party has to say. In my case against CSU's lawyer is probably going to want to take my deposition right off the bat and ask me, why do you think you were fired? Give me all the evidence that you have that you think, or tell me whatever evidence is you think that supports why you were fired. Tell me everybody you talked to about it, so on and so forth. It's a way to get information up front. It also locks in some kinds of testimony, because if we go to trial and I get on the witness stand and CSU's lawyer asks me, give me all the reasons that you think you were fired, and I list 5 discriminatory reasons, he or she might say, if my deposition testimony was different, well, at your deposition you only gave 2. Or at your deposition, I asked you about that aspect, and you said you didn't believe that was the reason you were fired. So it's a way to sort of get people's testimony locked down under oath to where if they changed it later, it would be bad for them. So those are depositions. Now, if I sue CSU for discrimination in employment, I'm the plaintiff, right? CSU's the defendant. Who might my lawyer want to take depositions of? We can't depose CSU, right? CSU can't speak. My boss, very good. We want to hear from her. Get her story nailed down, right? Why she fired Tebow? Because he was old and a man. And what else did I say? Methodist. Making up classes, protected classes. Who else? Boss is probably one of the most important ones. Maybe somebody from HR, maybe some of my colleagues, maybe my department chair, people like that who would have information about the case. So depositions, sworn interviews. Questions have to be answered under oath. Interrogatories are another form of discovery. These are written questions that are given to the other side, and they've got to supply answers in writing. Not as effective as a deposition at nailing down somebody's story, because I can't follow up in real time with a written question. I send it to them. I send them a list of 30 interrogatories. They send me their answers to 30 interrogatories. Then if I need to follow up, I could send another one, but that's awful cumbersome. So why would we even bother with interrogatories? Well, they're very helpful for things that, if I need somebody to list something, or if I want, say in a divorce case, I need to ask my wife's attorney for all of her bank accounts. List me all of your bank accounts. What bank they're at, what their account number is, whether they're checking or savings, whether they're an investment account, when you opened them, are there any other people's names on the account, things like that. Very good for basic information gathering. If I took her deposition and asked her to list for me all of her bank accounts, a couple things might happen. We might be there all night because I'm asking stuff that they could have just answered in writing that would have been easier. And also, we'd probably have to stop while she pulled her laptop up and logged onto her banks and figured out what the account number is. That's just not stuff that's in the head. So interrogatories are good for asking for lists of things or just some basic information that might need to be looked up. And they're also really good as a starting point. So I think that the tools of discovery, you could do no discovery. You could use every tool of discovery. It's up to you. But they are complementary in this way. So let's say that maybe before my attorney deposes my wife, I want to send the interrogatories and get those responses back. That way I can see where all of her accounts are, and then I can follow up with that in her deposition. Tell me a little bit more about this Bank of America account. I'm not following exactly when you opened that up and whose name was on it and that sort of thing. We've just saved a ton of time by getting the background through interrogatories and then letting me focus on what I want to ask her for follow-up in the deposition. There is also a discovery tool called a request for production of documents, request for information. This is where I could send a list of things that I want them to produce to me if they have them. All your bank statements for the last 5 years, all your credit card statements for the last 5 years, your tax returns. In my suit against CSU, send me his employment contract. Send me a copy of of my personnel file. Send me a copy of any complaints or any disciplinary things that have been initiated against me that are not in my file. send me every email that you have that mentions Mr. Tebow and employment. All right. Send me any pictures that you believe are relevant to the case. Send me copies of any tape recordings or videos that you believe are relevant to the case. Those would all be appropriate to ask in a request for production of documents. Also complimentary in that I might ask through interrogatories, list me all your bank accounts. And then in the request for production documents, I'm going to say, send me the actual copies of your bank statements. So they all can complement each other. If I get the discovery material, documents and interrogatory answers before I go to the deposition, then I can ask them about specific things in those documents. So if Ms. Marshall turns over her bank records to me in my lawsuit against her, and I get to study them and look at them, when I go to take her deposition, I can say, here's your January statement. Look at January 17th. What charge is that? Did you make that charge? What were you buying? So depositions are really they are good at the beginning to lock in testimony, but you don't want to do them too early before you've gathered information, because you want to be able to ask your questions in as detailed a way as possible. So the ones I want you to be familiar with: depositions, interrogatories, request for production of documents. Why did I say that discovery was crucial in the area of business law? Anybody have any thoughts from the business context as I'm describing the types of things that are open for discovery? Does that scare anybody? Yes. Say that again. Money trail, paper trail, right? How many of you in your jobs send emails? Everybody, right? Pretty much everybody. Do you, when you send an email or compose an email, do you think to yourself, I wonder if this will get read by somebody in a discovery in a lawsuit one day? We don't, but we should. I'm not saying you need to micromanage your emails, but I do want you to understand that the emails belong to the business. Even a personal email could be subject to discovery. So all that kind of stuff gets dragged back up. I like to use divorce cases again. I know they're not business law, but they're easy conceptually to think about. Some of the stuff that gets asked for in discovery in a divorce case: interrogatories. Tell me all the people that you've slept with since you've been married. Where, when, who, how. That'd be awful to have to write that if you were guilty of something. That would be awful to have to answer under oath in writing. Tell me all your email handles, so I can look up and try to do discovery on all your emails. Texts come up. I'll tell you what comes up the most is, not the most, but people sending explicit texts. In divorce cases, back when I used to do divorces, the stuff people would send, I would say you won't believe it, but you would probably believe it. But that stuff gets brought back up in a courtroom. Mr. Tebow, did you send this text? Yeah. I mean, is this you? Right? This kind of stuff can get dragged up. And I'm using the divorce case again, not to be sensational, but just to sort of impress upon you. Everything that you do electronically might be subject to discovery. We don't ever think we're going to get caught, or we don't ever think about that necessarily when we do some things. But in your business careers, you do have to think very, very hard and carefully about what you write, what you say, your work product, all that kind of stuff. all subject to discovery. Question?
So, if you're in a case that someone requests your personal email, you have to give it to them?
No, so that's a great question, which was, if somebody requests your personal email, do you have to give it to them? So the rules for what you can ask for in discovery are different than the rules of what I can actually put into evidence in a courtroom. Just because I ask for it in discovery and you give it to me, that doesn't mean I can automatically use it in court. It's still got to be relevant. It's still got to be germane to the subject matter of the dispute. So if I asked you for something, Mr. Wilmot, in discovery, and you felt like, let's say that you and I were, that I was going to buy a house from you and I backed out, and you're suing me because I backed out of it. And in our lawsuit, I want to know all of the email handles you've had since middle school. You could say, I object to that request. It's not relevant. Most of the time in discovery, though, the court will go ahead and allow it to be asked in discovery with the caveat that that doesn't mean they can use it at trial. So what the courts want to happen is they want as much information to be shared in discovery as possible, because they don't want to have to be making rulings early on in a case, refereeing fights about discovery all the time. Most of the time, as if it's generally, if it's possibly relevant. The standard is if it's calculated, if it's reasonably calculated to lead to the discovery of admissible evidence. Pretty broad. But let's say I get your, for some reason I get your emails from I don't get your email, but I get your email handles or something from middle school. And it turns out that there's some stuff in there that's unflattering for you, but it has nothing to do with me buying a house from you. If I try to use that at trial, you can object again, and the judge can say, no, that's not relevant. So there's some safeguards, I guess, is what I'm trying to say. But generally speaking, if we had a dispute over your emails and we went to court and I told the judge, hey, I asked for his email handles in high school, and he says, that's not relevant, that's not reasonably calculated to lead to the discovery of admissible evidence, the judge would look at me and say, Mr. Tebow, why are you asking? Can you give me a reason why that might lead to something that's relevant here? And if I say, well, I have reason to believe that he tried to sell this house when he was in middle school. His grandmother left him this house when he was in middle school. He offered to sell it to somebody else one time in middle school. I don't know. I'm really out on a limb now. But if I can tell the judge that what I'm looking for might be relevant, then they're more likely to let me do it, see if it is. And then if it turns out not to be, he can object to it at trial and say, that doesn't mean it gets admitted into evidence. So I hope I haven't made that more muddy, but that's a great question. I don't get to just ask you anything. I've got to be able to tie it to that somehow that is either relevant or it's going to lead to something relevant. Nowadays, if you work for a big company, these discovery requests for emails get sent to IT, and they can do a search of an entire server with keywords. You can type Tebow in. Going to bring up every email on the server that has that name in it. Then we can narrow it down from there. So electronic discovery is probably pretty burdensome to look through, but it's not really burdensome to produce, but it's not that burdensome to ask for. And so it's pretty typical that in a case, somebody's going to ask for copies of emails, texts, that sort of thing. All right, once the discovery period is over, and really at any time after the lawsuit starts, the parties can engage in various ways of settling their case. I'm going to skip over those for right now. But I might be negotiating with the other side. That's one of the ways that we could try to settle our case. We could go to arbitration. We could go to mediation. I'm going to get in a little bit more in depth to that in a minute. But let's keep on going. Let's assume that we don't settle our case. We're going to go to trial. This is the part you're most familiar with in the legal system. This is where the judge would be in the robe sitting up on the bench. This is where the jury would be. This is where the lawyers would get up and begin the trial by making opening statements. Ladies and gentlemen of the jury, or Your Honor, here's what our case is about. Here's what we think the evidence is going to show. I do want to make sure everybody understands that there's not a jury in every single trial. We do in this country have the right to a jury, but lots of times folks won't invoke that. Juries they can make a trial longer because we've got to pick a jury. They can be more unpredictable than a judge. Think about that. Anybody ever been on jury duty? All right, Mr. Alexander, what was this? What kind of case was it? Subject matter. I'm sorry, what kind?
It was multiple cases.
Oh, multiple cases. Okay, did you actually get picked for the jury? Was it a criminal case?
Some of them were, yeah.
Did you know anything about the subject matter of the case before you were on it?
No.
So see, you get a jury of peers, right? We don't really have juries. People don't pick juries in divorce cases much anymore. But in my divorce case with my wife, I am not looking forward to going into courtroom and having 12 citizens decide how we're going to split up my marital assets. They might not have any financial expertise, I don't know. They might not. So in divorce cases, a lot of times we just want to leave it up to the judge and not have a jury because the judge does them all the time. The judge is very familiar with the financial aspects of a divorce case. The judge knows what the law is. The judge can do it faster. So not every case has a jury. After the opening statements are made, then each side puts on their evidence. So it's not enough for me to stand up and just say, hey, this is a case, a breach of contract case. Miss Marshall and I had a contract and she broke it. She didn't fulfill her duties under the contract. I don't get to just stand there and say that. I've got to show the judge or the jury the contract. Here's the written contract if we had one. Here, anything that supports my contention that we had a contract. Maybe there's emails back and forth between us that I want to put into evidence. Maybe I recorded a conversation we had. Maybe I had my real estate agent talk to Miss Marshall a lot during this process. I want to put my real estate agent on the stand so she can testify as to what she told Miss Marshall and what Miss Marshall told her. I can't get up there and say what they talked about because that's called what? Hearsay, right?
So I kind of have a question. I thought you had to submit evidence to the judge and then they approve whether you can release the court.
Question is you have to submit evidence to the judge and then they approve whether or not you can bring it to the court. That is true. The way it works in a courtroom is if I have a contract that Mr. Wilmot and I signed, I'm going to call him as a witness. I'm going to show it to him and say, do you recognize this? I'm going to get him to identify it. He'll say, yes, that's the contract. Is that your signature on the second page, Mr. Wilmot? Yes, that's my signature. Is this a true and correct copy of the contract we entered? He says yes. Then I can then say to the court, I move to enter this into evidence. So I could start talking about it before it officially became into evidence, but it couldn't get in until the judge says for sure yes or no. Okay? He might say, that's not even an original. That's not my signature. I've never seen this before in my life. If I turn around and say, okay, Judge, I want to enter this into evidence as my exhibit number 1, his lawyer is going to object, and the judge is going to have to decide whether or not to admit it based on that evidence. Now, I might get another witness who says, yeah, I saw that. I watched him sign it. That's the one I saw him sign, and I might get it introduced that way. There are different ways I can maybe get it in. But yes, the judge has the final say about what evidence comes in and what evidence gets excluded. That answer your question? All right, after we present witnesses and evidence, and after cross-examination, that's when the other lawyer gets to ask the witnesses for the other side whatever questions he or she has. All right. In my divorce case, I take the witness stand. My lawyer is going to examine me, ask me all the questions that he or she wants to ask me. But then my wife's lawyer is going to get to stand up and cross-examine me on all the stuff that I said, challenge the things that I said, maybe ask me about some things I haven't talked about yet, maybe ask me about some evidence that I didn't bring up that they want to bring up. After all that happens and all the evidence is presented, then the lawyers make closing arguments, and then the court makes a decision, or the jury makes a decision, depending on whether or not there is a jury involved. A trial without a jury is called a bench trial. Back from our English legal heritage, the judge sits on what was known as the bench. And so they don't actually sit on benches now, but it's called the bench. So a bench trial is a trial without a jury. After the jury or the judge's decision, then that decision can be appealed. And I feel like we covered appeal last week, so I'm not going to get too much into appeal today. I got a little bit ahead of myself last week. So let's jump to alternative dispute resolution for a second. This is on page 4 of your outline. The vast majority of cases of litigation does not actually go to a trial. It gets resolved beforehand in other ways. In a criminal case, many, many times the defendant will enter a plea. They'll negotiate a plea. If you plead guilty to this, then we'll ask for this sentence, or we'll drop this charge. Each side needs to get something in order for it to be a good deal, right? The defendant is not going to enter a plea of guilty probably to every single charge. What would be the purpose of that? But I might enter a plea of guilty to arson if they drop the murder. Making that up. In civil cases, we're more talking about money, right? So those can very often be settled before going to trial if we come up with something that both sides can live with, a deal that works for both sides. So how are the ways that the system is set up for folks to resolve their cases before going to trial? One is that the parties and the lawyers are always free to negotiate between themselves from the get-go, all the way up, even once trial starts. Sometimes the lawyers continue negotiating. Sometimes something happens in trial that's not good for one side, and a previous negotiation that they did not agree to all of a sudden looks pretty good. So you might have a witness come in and just absolutely destroy a party or say something that is really, really damaging for one side, and they call for a break and resume negotiations. You could have it the other way too. You could have a witness come in and be so good that now that side is no longer willing to agree to what they offered last week. Price just went way up because things are going my way. But negotiation can happen from day one all the way up through trial. Another form of alternative dispute resolution is mediation. So mediation is relatively new. I say that meaning it's within the last 30 years it's really come along. Now mediation is pretty much required by the courts before you can go to trial. They want you to try mediation first. The reason is mediation has a pretty good success rate for a couple reasons. One is it could be that the parties just need to be able to sit down and negotiate in some sort of informal or more formal way than just lawyers picking up the phone and talking. Maybe they need to actually go to the mediation, have a mediator there. That helps. It also helps because prior to mediation, a lot of times, neither side has made an offer to the other. There's no requirement that you do. So we might get to mediation and I'll ask my wife's lawyer, make us an offer. Or they might say to us, make us an offer. We make one. This is the first time, maybe the first time in the case that she and her lawyer have gotten to see exactly what it is that I'm asking for. And then they can make a counteroffer, and it'll be the first time that I'll get to see exactly what it is that they're asking for. Then I can do something that I couldn't do before. Once I know what it is that they're asking for, then I can start weighing what they're asking for versus my chances of getting what I want at trial and what that's going to cost me in attorney's fees and time and being off work and emotional agony, all those sort of things. Is it worth it for me to settle? Would I rather pay a little bit more in some of these areas, maybe a little bit more than I'm willing to pay at mediation to get it over with, rather than risk paying all that to my lawyer and then going to trial and then getting a worse deal from the judge or the jury? It's always an evaluation of options. So by the time you go to mediation, you're actually getting a little bit more concrete idea of what your options are. Now, I used to be, I guess I still am, I just don't do it anymore, but I used to mediate, I used to be a mediator. And I really liked that because I'd go to mediation and I'd try to help the parties settle their case. And then if they couldn't settle it, then I was done. It's not my problem anymore. When I'm the lawyer for a party in mediation, if we don't settle, that's still my case. It's still ongoing. We're still looking at going to trial at some point. We still have uncertainty. Still a lot of work left to be done. But my experience was that, especially in mediating divorce cases, very often we would get to the end of a mediation. It could be 3, 4 hours, 5 hours long, and we have settled just about everything, but maybe we're still apart on child support or alimony. One side wants $500 more a month than the other side's willing to give. We didn't settle the case at mediation, but we did lay the groundwork for settling it later. There's nothing that stops the lawyer from picking up the phone the next day or the next week or the next month and saying, hey, if y'all are still willing to do all the stuff we agreed upon, we would be willing to pay that extra $500 a month you needed. Or we can't do the $500, but we'd be willing to pay $300. Or we don't care about that $500 anymore. Would y'all be willing to settle for the last offer that you made at mediation? So very, very often cases would get settled later on based on the groundwork that you did in mediation. So for that reason, even if it doesn't settle while you're there, it's very, very helpful. Again, when we finished mediation, if we didn't settle, I could look at my client and say, all right, this is what they offered. this is what I think the range of what a judge might do. I can't ever predict or promise what a judge is going to do, especially in a divorce case. A lot of that might depend on how good a job my client does when they testify. I've had plenty of clients who made terrible witnesses. But I can then explain to them, all right, I think I can do better at trial. I can't guarantee that. If you want to lock in this deal, you can lock it in now and your case will be done. If we go to trial, it's going to cost you X thousand more dollars in attorney's fees. And then these are the places where you might have more exposure. These are the things that might happen to you at trial that I can't control. And that way the clients can make a more informed decision about their risks. A lot of times in the business context, let's say that I sue CSU for slip and fall because the stairs were slippery and I claim that they should have had some sort of non-slip agent to protect students from walking on slick stairs. And I want $5,000. All right? Maybe that I have a bogus lawsuit, but it could be that CSU says, we'd rather pay him $5,000 because this is going to cost us $50,000 in attorney's fees just to get the case, just to defend the case up through discovery period. Just pay him and make it go away. So lots of times businesses make decisions in litigation based on the economics of it and not necessarily based on whether or not they felt like they have responsibility or not. Arbitration is the third method of alternative dispute resolution that I want you to know about. It is more formal than mediation. So I left out a couple of things at mediation. At mediation, the mediator doesn't make any decisions, doesn't have any power or authority to make decisions. The mediator's job is just to go back and forth between the parties with offers and counteroffers, help the parties understand where the other side's coming from, help the parties hopefully get to a resolution. So in a divorce case, it would look like this. Before COVID, we would all meet at the same place. Plaintiff would be in one room, defendant would be in the other room. I'd start off with one side. I would get a written offer or a list of things. He wants the sofa, he wants the upstairs TV, he'll pay $100,000 in alimony, he wants half of the retirement account. All right, I take that to the other side. The other side, we go through it one by one. He wants the downstairs TV. She says, fine. We settled something. He wants the upstairs sofa. She says, fine, he can have that. He wants $100,000 in alimony. She says, or he's offering $100,000 in alimony. She says, I want $200,000. So then I go back to the other room, and we keep going as long as we're making progress. We'll keep going back and forth. We've had mediations last as short as 30 minutes, and mediations last as long as 7 or 8 hours. That's unusual, but it can happen. We keep going until we see if we settle it. If we don't settle it, again, we tried, then we can go into trial. Arbitration is a little bit different because the arbitrator does make a decision. It is like going to trial before a judge without having to go to trial before a judge. Now, why might I want to do that? A couple reasons. I might decide in my breach of contract case with Mr. Henry that I've sued him in Superior Court of Muskogee County, Georgia. We just kicked off our lawsuit, and my lawyer tells me, well, it takes a couple of years for you to actually get to trial. We're going to start out doing discovery. We'll have to do some mediation, things like that. But we have to wait on our case to be old enough to earn its place at trial when the judge has room for us. Well, I don't want to wait 2 years. In divorce cases, somebody's got a girlfriend or a boyfriend. They don't want to wait 2 years. All right, they're ready to move on. So arbitration is a way to kind of skip the line and get your case decided a different way. Another advantage that arbitration has is that you could pick an arbitrator who has specific experience in an area. So if I'm in a construction litigation case, CSU hired my construction company to build a new building, we get into litigation over it because of cost overruns or I didn't build it the way they thought, I do not want to take my case to a jury of 12 people in Muskogee County who know nothing about construction. I really don't even want to go to the Superior Court judge in Muskogee County who might have been appointed 2 weeks ago or 2 years ago and was a trust and estates lawyer, has never had a construction case before. I want to pick an arbitrator who is an expert in construction law, probably a lawyer who practices construction law, probably somebody with experience arbitrating these cases. That way, I don't have to worry that the judge isn't understanding these construction terms or how it works in construction. I know that the person we're talking to who's going to make a decision knows what we're talking about. So that's another advantage of arbitration. It's also, I think it's cheaper than full-blown litigation. You're not paying a lawyer to take you all the way through trial. You can still do discovery. You can still take depositions. You can still prepare for the arbitration as if you're going to prepare for trial. But it does save some time. A lot of the contracts that you guys sign, you don't realize it, but a lot of the contracts that you sign, especially the stuff where we click the box, agree to the terms and conditions, have arbitration clauses in it that say, if we have any dispute over this, we're agreeing right now up front that we're going to settle it by arbitration and not regular litigation. Businesses really like that because they would much rather be able to settle these with less cost. So be careful about what you sign and what you agree to. You might be agreeing to submit your dispute to arbitration rather than going the regular litigation route. All right, back up for me to the first page of your outline. Let's talk about jurisdiction for a minute. Jurisdiction is the power of a court to hear a case, right? An Alabama court, generally speaking, does not have any jurisdiction over me because I don't live there. An Alaska court doesn't have any jurisdiction over me. I don't live there. I haven't done anything there. Generally speaking, courts have to have jurisdiction over the parties to the case, and they have to have jurisdiction over the subject matter. Is this the type of case that can be brought in this court? So the court has to have jurisdiction over the parties and over the subject matter. If Mr. Thiel sues me in Minnesota for breach of contract over me not selling him my house in Georgia, that Minnesota court is not going to have personal jurisdiction over me. If he sues me in a court in Minnesota, let's say he sues me in Georgia where I live and where the house that I was going to sell him is. He sues me in probate court. Remember that was one of the courts that was on our chart last week? He sues me in probate court. Does that court have personal jurisdiction over me? Yeah, it's a Georgia state court and I'm a Georgia resident and our contract is in Georgia. But it doesn't have subject matter jurisdiction because a probate court is limited in the types of cases it can hear. I'm not going to ask you on any quiz whether a certain court can hear certain cases. I do want you to know that a court must have jurisdiction over the person and the subject matter. So, jurisdiction over the person used to be a lot simpler than it is now. When I talk about the fact that an Alaska court doesn't have personal jurisdiction over me in Alaska, that's true unless the lawsuit has to do with something that I did or caused to happen in Alaska. So let's say that Mr. Hare lives in Alaska and he wants to buy my car on eBay Motors, and I sell it to him, and I ship it to Alaska, and I've defrauded him out of the car is a lemon. It's not what I told him I was selling. Don't work. Can he then sue me in an Alaska court for selling him a bad car in Alaska? Yeah, he can. This is called long-arm jurisdiction. And it's taken the idea that most people really are only going to have to be sued in the state where they live. It's taken that idea and it's expanded it now to say that people can be sued anywhere else as long as that lawsuit has to do with the activity or the presence or the actions that they caused in Alaska. If I'm flying to Hawaii and I stop in the airport in California and I'm laying over there to catch my flight to Hawaii, and while I'm in the airport in California, I get into a fight and I assault somebody, does California have personal jurisdiction over me to bring criminal charges over that fight? Yeah, I did it in California. I broke the law in California. So where this comes in for business law is that anywhere that you're doing business, you could be subject to in-person jurisdiction for a lawsuit that's brought having to do with that business. Advertising, the internet, publication, all of those things have made it very easy for me to do business in other places. If I list a car on eBay Motors, I'm actually advertising that car to anybody in the world, right? Somebody conceivably could go and log on eBay Motors in India and decide they want to buy my car. I can't hide from courts in places where I might be doing business. All right, and the way this came about is that back in the day, mail order catalogs were a thing. And somebody in the state of Washington, let's say, would order something from Maryland. It gets sent out there. They have a dispute about it. Back in the day, the person who lived in Washington might have to take the stagecoach to Maryland to see somebody, right? I mean, it just wasn't convenient. It wasn't easy for us to do that. Nowadays, not that hard at all. Is it expensive still for me to fly to Washington? Yeah, but it's not really all that inconvenient anymore. It's not so inconvenient that it wouldn't be fair for me to be there, to be sued in Washington. So the courts are going to look at what contacts the person has with the other state. And the rule is if there is sufficient minimum contacts to where it would be fair for that person to be sued there. This is for out-of-state defendants. Long-arm statutes are for out-of-state defendants. You can always go sue somebody in their home state. That's not inconvenient to them. Might be inconvenient to you, it's not inconvenient to them. But in order for you to sue somebody in a state where they don't live, They have to have sufficient minimum contacts that the lawsuit would be fair. In my example where I got in a fight in the airport in LA, and the person that I beat up has some pretty serious injuries, and they want to sue me for their hospital bills in California. The only time I've ever been to California in my 50 years is when I flew through the airport on the way to Hawaii. That's my only contact with California. Do I have sufficient minimum contacts with California to be sued over what I did when I was there? Yeah. Let's say that Mr. Hare bought that car from me off eBay Motors, and he moves to California. He was stationed in Alaska at the military base there, and then he moves to California. He sues me in California for the car that I sent him in Alaska. I've still been through the airport and got in a fight. That's my only contacts with California. Do I have sufficient minimum contacts with California that it's fair for me to be sued there over the car? Probably not. The only contacts I have is that I was there for 2 hours in the airport one day in my life. And it had nothing to do with Mr. Hare or selling cars or anything having to do with that lawsuit. Let's say that I have, last point I'll make and then we can go. A business in California, a car dealership in California. And I have a second home there. I have bank accounts there. My business, like I said, is licensed out of California. I spend half the year out there at my California dealership, half the year in Georgia. I sold a car to Mr. Hare on eBay Motors when he was in Alaska, delivered it to him there. He moved to California. Now he wants to sue me in California. I'm not a California resident, but the question is, do I have sufficient minimum contacts with California that it's fair for me to be sued there? My contacts now are not just that I went to the airport for 2 hours. I'm there half a year. I run a business that's licensed in California. My bank accounts are there. Yeah, you could make the argument that there are sufficient minimum contacts that it's fair for me to be sued there, even though the lawsuit has to do with something that I did when he was in Alaska. Kind of a sliding scale. The more contacts that a person has with another jurisdiction, the more likely it is that they could be sued there. The more that the contact has to do with the subject matter of the lawsuit, the more likely it is they could be sued there. That's why my 2 hours in LA where I got in a fight means it's fair for me to be sued over the fight, but not fair for me to be sued over the car. Whereas if I am basically in California half a year and own a business there and do all these things in California and own property, then it's more fair for me to be sued there, even though the lawsuit has nothing to do with my California contacts. So, big point for you guys is be careful where you're doing business and knowing that, I mean, look, none of us, I sell cars. If I have a car dealership, I don't know what the laws of Alaska are. I don't know what the laws of Wisconsin are. I barely know what the laws of Georgia are. Okay? But I do know this. If I sell something to somebody in Wisconsin, then Wisconsin law sure could apply to me. I might have to hire a lawyer in Wisconsin to defend me for something I did, for something I sold, for the business dealings I have there. And their law might be a little different than the law in Alabama, might be a little different than the law in Georgia. That's a cost, a risk of doing business. All right, so for Thursday, you have one case to read. It is a case about long-arm statute, about somebody who got sued in Georgia. I think it's a Georgia case. And the defendant said, we shouldn't be sued. It's not fair for us to be sued there. and you get to see how the court analyzes the contacts that the out-of-state defendant has to figure out whether or not it's fair for them to be sued in Georgia. I'm also going to pull up the examples of the litigation complaint and discovery and that sort of thing, and we're going to go over those as well. So main thing to do for Thursday is read that case. If you came in late, I think I covered everybody, but if you think I might not have gotten you, let me know. I got you. You were talking when I called your name, so I marked you present. You just didn't hear me. Mr. Alexander. Oh, okay, I didn't have you. All right. Tell me your name. What's your last name? Oh. You came, oh, there you are. Sorry. All right, so no Brooks, no Garcia, no Rochester, no Rose. All right, see y'all Thursday. Yes, sir.
Hey, how you doing?
Good.
Just wanted to ask that everything's okay. That I was missing the first week of it.
Yes. Did both of
I
y'all?
texted you.
Yes. Y'all have 0 absences.
Thank you so much.
But we do have 4 for the semester, so
Yes.
we got to be very careful about that.
Yeah, we're gonna have a couple of tournaments as well. We're gonna
Yeah.
be seeing.
I understand that, and I won't count those against you.
All right.
Just let me know ahead of time.
All right. Thank you very much.
Were y'all able to do the quiz last night?
Yes, 100%.
Okay. All right, so y'all are caught up.
Yeah.
All right. It is important for you to watch that video from the first day,
All right.
because it says what expectations are and how it's set up and all that
I
stuff.
saw it. All right.
So make sure you watch that.
All right.
All right,
Thank you
welcome.
so much.
Glad y'all are back.
Have a good one.
So,
Yes, ma'am.
yeah, these were the questions.
Oh,
Those-
thank you. Okay.
So, yeah, because when I was looking at it, I was thinking about
That
that part.
that is one of the reasons they took it.
Right. And then I know it was that one too.
Yeah.
But.
I
it
need
was
to just change these up because, like I said, I'm not trying to.
Yeah, the same.
I'm not trying to trick anybody. Thank you
Right.
for showing me
No
that.
problem. Yeah, because, see, that's what I had.
Okay, I had put where is it? This
You
one.
did have that?
No, I had where is it? Involved with the law.
That one.
Or not? Yeah, I had that one too.
Okay. And then,
Yeah.
yeah.
I
that's
need,
why
I
I'm
need to
like,
either take that choice out or make it more than one.
Okay.
Gotcha.
Thank y'all.
Thank you.
Yes, sir.
And then the fact that you have it to where I can't go back, I second guess myself a lot. And that's what usually messes me
But I
up.
like
Oh.
how it warned you, like when you try to click over it, to
Yeah.
tell you can't.
Oh, it'll tell you you can't.
go back. Yeah.
But I had one class where you didn't
Didn't do
tell you.
nothing.
Right.
So I'm doing you a favor. You
Yeah.
don't have to worry about it once you click it and go.
Yes. But thank you for giving extra time, because that does help too.
Yeah.
Yeah.
Because I have anxiety and everything, and that, my test taking is,
I try to just make it. I used to have to, like, there are some students who I'm required to give extra time to,
right.
and I would have to go in and do it each time. And so finally I just went in and I was like, I'm making everybody's extra long
Yeah.
and just hope it works.
I hate that. It always messes me up.
Well, you're going to do fine in here. Just one a week.
Yep, thank you.
Okay.